Can anyone tell if the live stream is live?
No problem. All right, this is Garza versus Castillo.
I don't know what happened. Okay. All right, let's try again. Mr. Scott, let's start over again. I don't know what exactly. I understand that there's been a lot going on. Let's get to the merits, please.
Sure. Your Honor, we're here before the court asking that the court compel and grant specific performance against the defendants, requiring them to complete the statutory repurchase that they offered and that my clients accepted on January 22nd, 2021. Now, can I share screen, Your Honor? Is that possible? I know you're having some technical difficulties.
I hope so. See, go ahead.
Your Honor, are you able to see the Plaintiff's Exhibit 109?
No. Can anyone else see it?
No.
Yeah, we're going to try one other thing, Your Honor. I'm sorry about the technical problem here.
Ms. Pettit, why don't you try to share an exhibit, see if it works? I'm just wondering if it's a problem with us or if it's a problem with him. Okay, yeah, go ahead and take it down.
Let's try again.
This computer is booting up. It had some kind of error message that came on saying there's something missing out of the thing that makes it boot up. And I have a lot of documents. Just see if you can fix it. Yeah, I have a backup computer I can use today, but you could just let me know. There's a lot of stuff.
Your Honor, I'm not sure what the technical problem is, but for some reason, it's not allowing me to show the document. But I'll proceed without it. It's Plaintiff's Exhibit 109. The court has seen it before. This is the January 5th settlement agreement. And I would point out, Your Honor, that this is this offer was made under the Residential Construction Liability Act, which is Chapter 27 of the Texas Property Code. And it is the wording, it was this offer that we accepted, my clients accepted, was written by the defendant's counsel. And in paragraph 1, the defendants made an offer that Versailles would repurchase the property at 2808 Maple Springs for $1.3 million. It was an all-cash offer, and that's in paragraph 1, and there's 6 other separate paragraphs that deal with the other aspects of their offer, all of which we accepted. Now, Your Honor, under the statute, the eligible party to buy back the property is either the contractor or the contractor's principals. It's clearly defined. The statutory scheme, the RCLA is a statutory scheme that allows a builder who has been accused of building a defective home by the homeowner to elect to make an offer to buy back the property. It's not a right that belongs to anyone else. So we proceeded through this whole process. They wanted a title company. That was not part of our deal, but we did it anyway. They wanted title insurance. They wanted everything to be checked. They wanted confirmation of legal descriptions. So we found the title company. We provided them with the settlement agreement, which they deemed to be the contract between the parties, where the buyer was Versailles Dallas Inc., and the sellers were Jordan and Aaron Zatoon. And everything was going along in fits and starts, but going along nevertheless, until about 2 weeks before the outside deadline, which was 45 days, March 8th, 2021. Sam Elchamy gets in touch with the title company and starts making all sorts of demands. He wants the title file to be transferred to a different party. He wants the purchaser on the title insurance policy to be taken off and changed. He wants the HUD statements to have any reference to Versailles Dallas buying this property removed. They want a release, which we find out in the deposition he intended would bar the children of my client from having a claim for personal injury related to the mold in this house. And it just went on and on. And ultimately, Your Honor, they never tendered the money. They never sent the funds. And instead, they brought forward behind our back, because we received no notice from them of it, of a third party who then started writing letters to the title company that he was ready, willing, and able to wire funds and buy the property, but never did. And then within a matter of a week, suddenly this person's money was no longer available and the investor had walked. And from the outset, Judge, we find, and this goes to bad faith and unclean hands, that at the time that these defendants made this statutory offer and then waved it in front of Your Honor for days and days and days, talking about how they were going to perform. And my client, Jordan Zatoon, testified on examination from my co-counsel, Joe Ackles, that he was seriously concerned that they were not acting in good faith, that they would not honor this agreement, that they would not do what they were supposed to do. And that's exactly what came to be, Your Honor. And that's why we are here. And this thing about an investor, we heard nothing about that until after my clients were given repeated assurances that this deal was going to be funded and that the Elchamys in Versailles would honor what they agreed to. And they insisted on a March 5th inspection of the house to confirm its condition and that it was vacant. So my clients needed to move out and put their personal effects and belongings and their children's bicycles and all of these things in storage, Your Honor, and then go into temporary housing. And then the Versailles and the Elchamys not only didn't pay the money, Judge, but when I deposed them and we got their records, the ones that they produced, they indicated that they never had the financial capability to make this all cash offer and to back it up. So this was a ploy, Judge, from day one. It was a ploy just like during the trial. 7 days before the trial, they blamed my clients for the damage to the house and said they had nothing to do with it. In their own documents that because we settled the case, we didn't get a chance to confront them with. Their own documents showed that they installed that driveway that flooded that house. And they were lying to the court then. And with regard to this statutory buyback, they did this to derail our trial. And knowing that my clients were in compromised financial state and in a house that by Mr. Elchamy's testimony, Sam Elchamy, was trashed, my clients were in a dire circumstance. And then they played this game and they went along with it. Now, Your Honor, with regard to the closing, I have the title company general counsel will testify that they couldn't close this transaction because the defendants would not set a closing date and would not wire the funds. They never tendered their performance. And in addition, they sent documents to the title company, Trek contracts that we were not even shown. So they send in all these documents to the title company This was all along, they wanted to blow this thing up and make it impossible. And in fact, they succeeded because the title company determined that they could not proceed in the way that the El Chamis wanted to proceed. They could not transfer the title policy to another company. They could not, in the absence of an amendment of the settlement agreement, go and do what they wanted, which is they wanted to essentially make paragraph 1 of their settlement offer disappear at the title company. They didn't want to sign anything that would properly show that Versailles was buying the property. And they also, Judge, demanded that my client sign a release, even though they had not tendered their performance, that had no carve out for the performance under the settlement agreement. And if we had signed a TREC contract, the one that they proposed, we would have no recourse. So we would have wound up with a situation in which that would release the defendants from the settlement agreement, and then we would have this shell company to sue and no remedy. So my clients, Your Honor, have been trying every which way, both before and after the time that they claim that the investor walked away. We have repeatedly asked them to get in touch with the title company after March, multiple times, to get in touch with the title company, to fund this transaction, and to buy back the property in accordance with the settlement agreement. And furthermore, Your Honor, they have come up with, in their trial amendment, all sorts of excuses with regard to issues that were resolved long prior to the March 8th closing date. They're just red herrings, Your Honor. Things like your client was trying to get away with not paying their own taxes. That is not what happened at all. And you'll see the documents on that. But at the end of the day, Judge, we're here because the defendants are playing games, are acting in bad faith, have made false representations, and have acted under false pretenses and with unclean hands. And we ask the court to enforce the statutory buyback and to also award the Zatoons a portion of their legal expenses and moving costs and expert fees from the $200,000 that was put in the registry of the court. Thank you, Your Honor.
Ms. Pettit,
You may proceed, Your Honor.
you may.
And may I share screen?
You may.
Okay. Is it showing up? I'm hoping.
Yes.
Okay. Your Honor, during the trial, as you're aware, we made an offer, which is our Exhibit 119. This is the offer, and it was made during trial before the plaintiff had rested their case. During trial, after we had made this offer, the court announced its inclination on how you were inclined to rule. And what you told the parties is that you were inclined to find some amount on the breach of contract case against Versailles, but that you were distinguishing between two different types of damages, both the water damages and those other than the water damages, that you were making a distinction in your mind between those two sets of damages. And you indicated that you were not inclined to find in favor of the plaintiffs on any of their many tort claims that were alleged. As we predicted after the court announced that inclination, within, I think, maybe just an hour or shortly after trial ended that particular day, the plaintiffs accepted the offer that we had made during trial. The thing I want to point out right at this moment is that Mr. Scott has multiple times during his opening statement indicated to the court that this was an all-cash offer. But if you look at bullet point 1, nowhere in here does it say that this was a cash offer. It was very clear that we were going to buy the property for the $1.3 million. There's no word cash in there. There's nothing that prohibits us from being able to borrow money or take out a loan in order to effectuate this transaction. So there's nothing in here that says cash. Anyways, time moves on, and as you're as your honor knows, we filed an emergency motion to enforce the settlement. And I told Mr. Scott over and over in front of your honor, Mr. Scott, this buyer that's funding this transaction is about to walk. Please, please let us pay you $1.3 million. Let your client get this $1.3 million. Please don't stand in the way. I reminded him in front of your honor multiple times that bullet point 3 on this offer that they accepted said that there would be an execution of general warranty deed by the Zatoons to Versailles or their assigns. It was clear from day one that this was assignable. Mr. Zatoon and Ms. Zatoon simply shouldn't have executed this settlement offer if they were not willing to do it. So at the emergency motion to enforce, we begged them to please comply and allow us to deed the property to the assigns as the offer clearly allows us to do. But Mr. Scott refused. Mr. Scott is arguing today that there's some sort of special sacred breach when it's an RCLA situation. I've put some law up here from the Dallas Court of Appeals from 2006. There's nothing special about a breach of an RCLA offer. It is just a straight up breach of contract offer. If there is a breach of it, it is a breach of contract suit. There's nothing new or unique or anything that needs to be determined. So his statements regarding the RCLA are simply out of context and not accurate. So we've got more case law on this, but breach of RCLA is just simply a breach of contract claim. After the settlement was accepted, we complied, and within, I can't remember what the time period was, whatever the time period was, we obtained the $200,000 and it's sitting in the court registry. During that, I believe it was during the hearing on the emergency motion to enforce, Mr. Scott complained that his clients didn't have money, so we voluntarily released $12,500 to the Zatoons so that they could meet their, apparently their immediate needs. So we complied, and that money is still sitting there in the court registry, less the amount that was wired to the Zatoons. We believe, Your Honor, there's 3 ways in which the Zatoons are in breach of their contract. First, they refused to sign a deed to the assign of Versailles. They refused to cure a tax lien, and they would not sign the confidentiality and release as required under the settlement offer that they accepted. The first thing that happened, which is quite concerning, Mr. Scott said that we wanted to, I believe in his opening, he said we wanted to verify legal descriptions. We did, Your Honor, and there's a very important reason for that, which is as soon as this was over, Mr. Scott prepared a deed by which he was going to purportedly transfer title from the Zatoons to my client. However, what Mr. Scott was up to was transferring only half of the property to my client. As Your Honor recalls, I'm sure, the entire trial was focused on 4 lots. This testimony that I have here on the left-hand side of the screen is Mr. Zatoon's testimony where he says it's 4 lots, that it's almost an acre. We talked about this over and over during trial. Here's his testimony here where he's telling Your Honor that it's almost an acre. However, when Mr. Scott initially sent his deed over, even though we all know it's 4 lots, he sent a deed for lots 3 and 4, omitting conveniently lots 1 and 2, and attempting to transfer only 0.4 acres of land. Of course, Your Honor, that's not what the settlement agreement contemplated. And I'm sure Mr. Scott or his clients thought that perhaps we wouldn't notice it, but we did. And that was just the first of many, many issues that we ran into during this closing, Your Honor. That is the subject of a motion to compel that has not been, that's still pending. The law firm of Newman and Lawler was the one that was apparently, according to Mr. Scott, working with him to do these different deeds that were being drafted. We had filed a motion to compel, Your Honor, required them to produce a privilege log. We've reviewed the privilege log and filed a supplement to our motion because we believe that all of these communications should be produced so that the court can see, or at a minimum be produced in camera for the court to review, so that the court can see exactly what was going on behind the scenes when Mr. Scott was drafting these deeds, attempting to convey only the half of the property to my client. Time certainly went on, and the next issue, as I mentioned, is the tax issue. It's very clear in bullet point 1 that the transfer had to be free and clear of all liens. However, despite the fact, Your Honor, that Mr. Zatoon testified on the stand that he had paid the taxes on the property, that was his testimony, it was on July 6th. He testified, Your Honor, that he had paid the taxes on the property. That was absolutely not the case. You can see right here that there is a tax lien on the property for the prior year for nearly $20,000. Then what happened? And just to be clear, I've quoted section 32.01 of the Texas Tax Code, which shows that if there's an amount that's due, it becomes a lien on the property as of January 1st. So after the date that he testified, and certainly by the time that we were going to closing, those amounts were due and unpaid, therefore creating a tax lien on the property. Now, what Mr. Scott's going to try and argue, and we'll have evidence on this, is when this issue came up and it was clear that Mr. Zatoun hadn't paid his taxes, Mr. Scott then began making demands on my clients to pay moving costs and all of this other further compensation that Mr. Scott was saying, okay, if you're going to make us pay the taxes, then you have to pay all these other things under the statute. Your Honor, the settlement agreement speaks for itself. Those 7 terms are the only 7 terms. Mr. Scott doesn't get to say later on that he gets to add a bunch of moving expenses and things of that nature just because those might have been covered under the RCLA. The offer was the offer. It was accepted as is. They don't get to add terms, and that's what they continued to do during the duration while we were trying to get this deal closed. Your Honor, I covered number 3 already. Clearly, this was an assignable purchase. And the entity that was created by an individual that you'll hear from during this trial is an individual by the name of Ken Lambert. Ken Lambert was the one that was going to fund this transaction. On the 23rd of February, he created an entity, 2808 Maple Springs. That entity was the one that had the funds, and Mr. Lambert, on behalf of that entity, was ready, willing, and able to close that transaction until even after the date of the emergency motion to enforce that we had filed to try to make this deal happen. Mr. Lambert will testify in front of Your Honor that he did indeed have the sufficient funds to close the transaction because we'd put the because we'd put the $200,000 in the court registry. The amount that he had in the account for 2808 Maple Springs LLC was more than enough to cover the remainder of the transaction. As you'll see, there was a lot of communication with the title company. This is an email with Ms. Cross, who was the escrow agent, to our side saying Mr. Scott would not agree with the deed from sellers to 2808 Maple. Ultimately, Your Honor, when it all boils down to it, this is the biggest cause on why we could not get this transaction closed and why the Zatouns are in breach, because they refused to allow us to assign it, even though the contract certainly allowed. They then, part of the settlement was also that there had to be a confidentiality and release. The only release and confidentiality agreement that the Zatouns ever were willing to sign was Mr. Scott's version, which carved out claims or causes of action if the opposing party fails to strictly comply with its statutory obligations. So he's sending this release, which is the only one they were willing to sign, while at the same time telling us that he believed under the statute we had to pay moving costs. We had to pay all kinds of other things that simply weren't part of the offer. So there was no release and confidentiality provision ever signed that would have been required under the offer they accepted. There's 3 different ways that I think Your Honor can view this alleged breach. Option 1 is the court finds that there was no settlement because there's not a meeting of the minds. And as I represented to Your Honor before we started this morning, I think in that instance, the settlement fails and we have to go back and try the underlying dispute on the warranty claims. The second thing Your Honor may find is that the Zatouns breached the contract. Again, if the court finds that the Zatouns are the ones that are in breach, then the court can declare that Versailles, my client, is excused from further performance, and we go back onto the underlying warranty claims. Under the third option, the court can find that my client, Versailles, breached the contract. In that case, I think Your Honor has already alluded to this, that the court and its interns had done some research and that the measure of damages in that instance is the difference between the fair market value and whatever the settlement amount was. And then in that instance, of course, the Zatouns would keep the house, but they would receive the monetary damages. That is that differentiation there. We believe that it should be option 1 or option 2. Frankly, I think it's option 2, which is that they have breached the contract. And I think we'll show Your Honor that in this bifurcated trial. In that instance, we go back to where we left off, which was the warranty claims. I'm going to skip over this because I know that's bifurcated, so I'm not going to discuss that right now. At the beginning of trial, the first time, I told Your Honor that this was a case of no good deed goes unpunished. That has rang true over and over, and I would say now, I'll add to that, just ask Mr. Lambert. Mr. Lambert was a third party who was coming in to save the day. This was a white knight that was coming in to pay the Zatouns $1.3 million for a house that their own expert has said is only worth $500,000. So Mr. Lambert was ready, willing, and able. He will testify that he was ready to close that day, that what he needed was that deed to the entity that was funding the transaction under this transaction that was clearly assignable. They refused the money. They refused to close. They've now drug him to court. He's been through subpoenas. He had to hire counsel. He's been subpoenaed today, maybe released, maybe not, had to enter into all kinds of agreements. He had to file an affidavit this morning. So Mr. Lambert now, a third party who again was trying to help out these attunes, just like my client has been all along, is punished. So for those reasons, Your Honor, we think we will show you that it was the attunes that breached the contract. And thank you for your time.
Okay. Call your first witness. Mr. Scott?
Yes, Your Honor. Your Honor, I call the plaintiff Aaron Zatoon.
All right, Ms. Zatoon, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole, ma'am, you need to raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I think you're muted.
I'm not muted. Am I muted?
No, I think she's muted, Your Honor. I
Yes.
couldn't hear her.
Yes, I swear.
All right, let's proceed.
Thank you, Your Honor. Aaron, you're one of the plaintiffs in this lawsuit against the El Chamis and Versailles Dallas Inc.
Yes, I am.
Okay. And were Versailles Dallas Inc. and the El Chamis the contractor that built your family home at 2808 Maple Springs in Dallas, Texas, starting in or about 2017?
Yes.
Are you currently living at the 2808 Maple Springs address?
No, I'm not.
During the trial, Aaron, were you residing at 2808 Maple Springs, or had you been somewhere else?
During the trial, I was in upstate in Baltimore area with my sister. She was helping me watch my kids during the trial.
Okay. And so when approximately did you depart the Maple Springs home and go to first visit your sister?
She got married. It was like a small little COVID kind of wedding. We weren't able to go to it, but it was right before Christmas. So we left. It was right after Christmas. We went up there to celebrate with them.
And approximately, can you tell us the date of her wedding, please?
I think it was a day or two before Christmas. So I think maybe it might have been the 24th, something like that. It was a Christmas little wedding.
So in December of 2020 is what we're talking about?
Yes.
And did there come a point in time when you came back to Dallas?
Yeah, we came back. Well, we were waiting. There was, a time period where we're getting everything ready for the closing, like all the paperwork and things. And so we came back right before the buyback was supposed to close, so we could move our stuff out of storage and go somewhere. So. Okay.
And have you received any of the, other than the $12,500 that the judge released from the registry, have you received any other funds from the defendants on account of this buyback?
No, I haven't.
And was the buyback closing supposed to take place on March 8th, 2021?
Yes, that's right.
And prior to March 8th, 2021, did you and your husband execute any documents and send them to Trinity Title?
Yes, we fully cooperated with the title company. I believe we did send in a deed that it was exactly how the settlement agreement wrote it there. So I don't know much about like all the different things with the title stuff, but we fully cooperated with them. So I didn't think there was an issue at all.
So Aaron, when you say you signed a deed that was exactly as the settlement provided, can you tell me whether or not you signed a deed from Jordan, you and your husband signed a deed in March, early March of 2021 that was to Versailles Dallas Inc. and or assigns exactly the wording in the settlement agreement?
Yes, I believe we did. It was, I remember it was exactly the way that Miss Pettit or Pettit, Miss Pettit wrote it. So I don't know why there would be an issue with that.
Can you tell the court also whether or not prior to March 8th, 2021, you provided the title company with keys to the property?
Yes, we provided the keys to the title company.
And Aaron, can you let Judge Hoffman know whether or not you made arrangements for movers to move all of your family's personal effects to vacate the property at 2808 Maple Springs on March 3rd and March 4th, 2021?
Yes, we had movers move all of our stuff March 3rd and 4th, I think.
And did you do that because it was your understanding that under the settlement agreement, paragraph 2, you were required to move out on or prior to March 8th, 2021?
Yes, that was our understanding. We wanted to fully cooperate. We obviously want this buyback to happen. So we made sure that we were out of the property just so it was ready to go.
And Aaron, where I know this is hard for you, Aaron, where are your children's toys and personal effects and clothing at this time?
Well, we put all of our stuff in storage, and we were waiting for the buyback to happen so we could like get our stuff out of storage and maybe go somewhere else. I don't know where, but right now we still have all of our belongings in storage, like all of my clothes. I just have a suitcase of clothes, and all of my kids' toys are in storage. And it's just been hard because having little kids, I mean, they're asking about their toys. They're asking, where are they? They're asking about, like, my daughter, who's 3, she asked, why aren't we going to our house? And I want my frozen room because she likes her frozen bed. And it's just hard to explain it to her, but.
Aaron, if Judge Hoffman was to decide that there would be different wording on the deed in order to complete this buyback, are you willing to sign whatever deed the judge finds is the appropriate language in order to effectuate this and move on with your life?
Yes, yeah, anything that Judge Hoffman would say, like, to agree to make sure that the buyback can happen, I would be happy to do that. I'm not trying to stand in the way by any means.
And Aaron, you heard in Ms. Pettit's opening statement that she talked about a Kenneth Lambert. And I want you to tell the judge, have you ever had any contact? Did a Kenneth Lambert ever contact you as one of the owners of the property about buying the property at 2808 Maple Springs?
No, I've never spoken to Mr. Lambert.
Okay, and have you ever, to your knowledge, have you ever met Mr. Lambert after this settlement agreement was entered into?
No, I've never met him either.
And did Mr. Lambert ever communicate with you by text message or email indicating that he'd like to look at your property at 2808 Maple Springs and potentially consider
Sorry,
making you an offer to buy
Just
it.
one second, one second, guys.
Sure, Your Honor.
Sorry about that. They were fixing my other computer. Okay, go ahead, Ms. Zatoon. Or
Oh.
go ahead, Mr. Scott.
So, Aaron, I don't recall where I was. I don't know if you answered the last question, but let me ask this. Can you tell the judge what your living circumstances have been since the buyback didn't close?
Well, it's been a really difficult situation. We were dependent on the buyback to close so we can move on. So we've just been pretty much in like hotels or temporary housing and we've had to move a lot, like probably every week or two, sometimes every couple days. And it's been terrible, really. That's why we really need Sam and Dylan and Versailles to honor the buyback. For us, it's been hard. I've had to, cook. I had to cook like meals in my hotel room with like my Instant Pot and stuff. I'm trying to be creative, but I really can't keep doing stuff like that. We really need to get out of this bad situation. It's really hard with two little kids going through this and like two dogs too that I'm carting around everywhere. So it's been a nightmare.
Now, Aaron, was it your intention if Versailles and the defendants had sent the money and funded the closing at Trinity Title, was it your intention that unpaid real estate taxes would be paid from the closing proceeds from the money that you were going to be getting from Versailles?
Yeah, I think that's how a closing normally happens. From what I would think, it's any taxes or anything that just gets paid at closing. So I don't think that's a problem.
And Aaron, are you aware that prior to Trinity Title being engaged, that there was some title work, including a legal description that was prepared by another title company?
I didn't really know about it, but I think I found out about something like that after the fact.
Are you aware, Aaron, as to whether or not prior to March 8th, 2021, the legal description for this property, that there was a legal description prepared for this property by Trinity Title that included all 4 lots and a proper legal description?
Yeah. It was any issue that I guess that other law firm did. I think it was completely fixed and ready to go, like for closing.
So Aaron, as far as you understood it, on or prior to March 8th, the legal description for the property was 100% correct and had been checked by Trinity Title. Is that right?
Yeah, it would. That's what I believe, that it was completely 100% correct, ready to go for closing by March 8th.
And at any point in time, were you provided with a contract, a real estate contract, a sale agreement, but signed by Kenneth Lambert or 2808 Maple Springs, promising to buy your property for $1.3 million by March 8th?
I don't believe so.
And Aaron, have you ever seen any notices from the El Chamis that they had entered into an assignment in which some third party had assumed Versailles obligations under the January 5th settlement agreement?
I don't believe so.
Aaron, can you tell us about what impact on the buyback not closing has had on your children?
Well, it's upsetting. Like it's really upsetting because we're in a bad situation because of it, and we need help, and not a lot of people can like help in this scenario, like friends or family. So at least my one daughter is young enough to not really notice, but I'm hoping that my 3-year-old doesn't notice too much. But yes, it's been really hard. I've had to put my 3-year-old's favorite thing, which is her bike, in storage, and I didn't have room for it in my car and stuff, and keep traveling with it here and there, and so it's been upsetting because she cried when I put it in the storage unit, and that's why it's so important that we have the buyback and can get out of this scenario like immediately.
Now, Aaron, at any point prior to you moving your belongings out on March 3rd or March 4th, did the El Chamis or Versailles ever tell you that they never had the money to fund this buyback?
No, they never disclosed that they didn't have the money to actually buy it back.
Did they ever tell you, Aaron, or put in writing to you? Let's start first with Plaintiff's Exhibit 109, the January 5th settlement offer. Is there any language in there that you understood to say that the defendant's $1.3 million offer was subject to financing?
That wasn't my understanding when I read the settlement agreement.
And Aaron, when you read the settlement agreement, did you have an understanding that you as the sellers would be taking the risk that if the defendants didn't secure an investor who was willing to pay the money and assume the settlement agreement, that risk would fall on you and they wouldn't have to honor the settlement.
I had no idea that that could happen. I thought they had the money to buy it. I didn't know.
And Aaron, were you present during the May 24th deposition that I took of Sam Elchamy?
Yes.
And did you hear him testify that in January of 2021, when Versailles made the offer, the bank statement that they've provided us at Wells Fargo indicated that Versailles only had $17,500 in its bank account when it made that $1.3 million offer?
Yes, I heard that.
And how did that make you feel when you heard Mr. Elchamy say for the first time at that deposition after the fact that they only had $17,500, that Versailles only had $17,500, and that they made this offer for $1.3 million to buy your property in order to stop the trial?
I felt tricked, and yeah, I felt like they did it to stop trial. I don't know, that was my impression of it.
And Aaron, after the settlement was entered into on January 22nd and accepted, did you become aware of certain information from the city that you considered as to whether or not it would be appropriate for you, your family, to move back into the 2808 Maple Springs property?
Your Honor, I'm going to object as to relevance. If we're going to try the defect case, I think it should have all been tried at once. I think the court has bifurcated those issues. And so the condition about the property or permits simply isn't relevant for the bifurcated trial.
Your Honor, the purpose of this is that this pertains to two things. One, it has to do with our trial amendment on the sanctions and the misrepresentations by the defendants. But furthermore, it addresses the post-settlement question that Your Honor raised, which is a number of hearings ago, you had not made a ruling on this, but you said to the Zatoons that if this doesn't close soon, the Zatoons may need to just move back into their house. And so I'm offering this testimony for the purpose of the court understanding that that is not an option for the Zatoons, and why?
I don't remember if I made that comment. You probably recall it better than I do. I'm not ordering them to return to their house. I was probably just making a comment that they may.
I know, Your Honor.
And I just want to say to Ms. Zatoon that I think nobody wanted this deal to work out more than I do. I really feel bad for you that this didn't work out, and I wish it had. And I feel bad that you've gone through all of this. I don't really see why this is relevant for this part of the case, but I'll allow you to go into a brief amount of this. But I just want to make it clear, to the extent that I made a comment that you might have to move back in terms of, because the settlement may fall apart. I wasn't trying to in any way indicate that I was ordering you to go back. And if you understood it that way, I apologize. That was never my intention.
Judge, just to clarify, no, what I was saying is it was merely a comment as to what might happen if the settlement did not consummate, as to what the Zatoons, the situation that presented itself. Your Honor never made an order directing such a thing.
Okay. All right. Let's go.
So, Aaron, can you tell us whether or not you became aware of certain information after the settlement was made that caused you not to have the ability to move back into the Maple Springs house?
Yes, it was my understanding that the city said it was maybe illegal to occupy the property. I guess it was maybe because of, all the permits were revoked, or I think they weren't even done properly the first time around. It wasn't just the CO.
Your Honor, I'm going to object as to hearsay and move to strike that answer. It sounds like her knowledge of this is not directly from the city of Dallas. So for that reason, we think it's hearsay.
I do think this is probably hearsay. I'm not going to strike it, but I agree, sustained. Anything else, Mr. Scott?
Yes, one second, Your Honor. I just want to look at my notes, if you bear with me. Aaron, if Judge Hoffman, separate and apart from the form of the deed, was to impose any conditions or requirements on you and your husband in order to consummate this buyback based on the judge's interpretation of the buyback agreement, are you prepared to fully comply with whatever the judge requires?
Yes, whatever Judge Hoffman says that we need to do to make this buyback happen. I'm sure me and Jordan would be willing to do anything to do that.
Your Honor, I pass the witness.
All right. Any cross?
Yes, Your Honor. Just one moment, and may I share screen?
You may, I think. Is it still enabled? I think it's still enabled. Yeah, it's still enabled.
All right, Ms. Satoon, you testified a moment ago with your lawyer that you signed a deed to Versailles and or signs using that exact language. Is that what you testified?
Yes, I believe it was the same wording in our settlement agreement.
And Ms. Satoon, you did not do that before the closing date of March 8th, 2021, did you?
Yes, we did. I believe so.
Okay, well, we'll go through some documents in a moment. But are you sure it's your testimony that you signed a deed to Versailles and or signs prior to March 8th of 2021?
Yes, I believe so.
Okay. Let's look at just a moment.
Give me 1 second. Go ahead, Ms. Pettit.
Thank you, Your Honor. All right, Ms. Satoon, I'm going to share screen. This is part of Exhibit 129. And the Bates number for the record is Versailles 8903 through 8906. I'll zoom in a little bit, Ms. Satoon. Can you see that this is an email from your attorney to myself and Mr. Urtiago on March 12th, which is after the date of the sale and buyback of March the 8th?
Yes.
And do you see that your lawyer says the alternate deed will be at Trinity Title and Escrow on Monday, March 15th, 2021?
Yes, it says that there.
And you see, I'm going to click to the next page of this exhibit, which is the deed that was attached to your attorney's email. Do you see that?
Yes.
And this is not a deed to 2808 Maple Springs LLC, is it?
I don't know.
Well, do you see 2808 Maple Springs LLC listed anywhere on this deed?
No, I don't.
And even this deed, which is using Versailles, Dallas Inc. and or assigns, according to your lawyer, wasn't even going to be to the title company until March 15th, true?
That's what that email says.
And Ms. Thune, you were at the hearing on the emergency motion to enforce, weren't you?
I believe so.
And so you heard us tell Judge Hoffman that we needed a deed prior to the closing date to Versailles and or assigns, correct?
I think so.
And that we needed a deed to the financer, which was 2808 Maple Springs LLC, true?
I'm not sure, but maybe.
And to this day, you've never signed a deed to 2808 Maple Springs, true?
I think that is true.
Okay, I want to look at what's part of Exhibit 125. And the Bates number of this is Trinity 1307 to 1310. Do you see this tax certificate regarding your taxes on the property?
Yes.
And Ms. Thune, these taxes still remain unpaid, correct?
I believe so.
Okay. I want to look at Exhibit 118B. Does this appear to be an email from your attorney to me on February 3rd, 2021?
Yes.
And if we go to the end, he's attaching a deed to a proposed deed to the property, correct?
Yes.
And you'll see on Exhibit A, it shows that this only includes lot 3 and 4 with a total of 0.4 acres, true?
Yes.
Ms. Thune, you knew your lot is bigger than 0.4 acres, true?
Yeah, I think it's almost an acre, I think.
Okay, I want to look at Exhibit 125, which is Bates numbered Trinity 1364 through Trinity 1383. Do you see this as an email from the title company to, an email from the title company talking about a new order on 2808 Maple Springs?
Yes, it looks like that.
And your attorney is the one that coordinated with the title company, correct?
I don't think I didn't do any of the title stuff, so I'm not sure.
Okay, let's look at what was attached to this new order placed with Trinity Title. Give me just a minute.
Okay.
It's on the next page. And if we go to the end, let's see here. I'm looking for is page 1377. Give me just a minute. Here we go. This is attached to that email and is again a legal description showing 0.4 acres and only 2 lots, correct?
Yes, that one does. Mm-hmm.
Now I want to look at Exhibit 129, Bates number 7556 to 7569. This, Ms. Thune, well, back up. Before we look at this exhibit, Ms. Thune, I have a question for you. You've heard your lawyer represent to the court that no additional contract was ever necessary in order to close this transaction, true?
I don't think he said that. I think he said it was never presented to us.
Ms. Thune, I understand that's what your lawyer was referring to about a contract that we had proposed, but don't you recall your attorney representing to the court that we could use your title company because a contract was not necessary?
I think he said that he found a title company that can take an RCL buyback, which is the settlement agreement.
And he said that could be done without a contract, correct?
I think from my understanding, yes.
Okay. Actually, we'll come back to this exhibit. I want to look briefly at this. Here we go. Versailles. This is part of Exhibit 129. It's Versailles 7605. Do you see that your attorney is saying in this that your title company, the third bullet point, says does not require a second agreement? Do you see that?
Sorry, could you just make it a little bit bigger?
Sure.
For me? Thanks. Yeah, it's small on my screen.
Sure. Do you see that your attorney is saying that your title company in the third bullet point does not require a second agreement?
Sorry, what did you say there?
Sure. You see that your attorney is saying that the title company does not require a second agreement. And the third bullet point, it's highlighted.
Yes. I mean, yes, that's what it says there in the email.
Okay. So your attorney had told the court, and then here is telling us that your title company does not require a second agreement. But if we go to Exhibit Trinity 1360, which is part of Exhibit 25, your attorney has sent a TREC agreement to the title company, correct?
Sorry, what did you just say?
Sure.
The internet going in and out, sorry.
Your attorney had sent a copy of the TREC contract to the title company, even though he said one was not necessary. True?
I don't know. I don't think so. I don't think he had a TREC contract.
Do you see that the title company here is telling your attorney on February 10th, before my clients had even met the title company, I have reviewed the TREC form and the settlement agreement.
I'm not aware of another TREC form, so I don't know. I don't know what he would be referring to there.
Looks like they're referring to a TREC contract that your attorney had sent to the title company before we were introduced to the title company. True?
Objection to form. Mischaracterization.
I've never seen a TREC contract that my attorney presented to settle to the title company.
So, Ms. Toon, your attorney never showed you a TREC contract that was submitted to the title company?
That's sorry?
Your attorney never showed you a TREC contract that he had submitted to the title company on your behalf?
I believe your client submitted a TREC contract to the title company and we never received it.
Ms. Toon, would it shock you to learn that your attorney had presented a TREC contract to Trinity Title and not told you?
Objection.
No, I wouldn't be shocked.
Okay, I'm going to go back to.
I don't think they can hear me.
Ask if they can hear me.
One moment.
Ask if they can hear me. Can I hear you, John?
I don't know. Are you, Julie, are you able to hear me?
Yeah.
I can, yes.
Okay.
Ms. Toon, I'm showing you a part of Exhibit 125, which is from Trinity when your attorney submitted the order. Have you ever seen this TREC contract before? That's Bates March Trinity 1365. I'll scroll through it so you can look at it.
Yeah, yeah, I can't quite read it.
Okay, let me zoom in. Have you ever seen this before?
Not that I remember. It probably is I mean, I don't know, but it probably is just a standard TREC contract. I don't know.
Well, Ms. Toon, were you aware that your attorney submitted this TREC contract to the title company after telling the court and telling myself that a TREC contract was not necessary?
I believe that's the title company said that the settlement agreement is all that we would actually need to close. Or
Ms. Toon, that's not my question. My question is, are you aware that your attorney submitted this TREC contract to the title company after telling the court that no TREC contract was necessary and telling myself that no TREC contract was necessary?
Sorry, the internet went in and out. Could you repeat that, please?
Sure. Are you aware that your attorney submitted this TREC contract to the title company after telling the court that no TREC contract was necessary and telling myself that no TREC contract was necessary?
I don't know about this. I mean, it's not signed or filled out, so I don't know.
It's filled out. It's got your name on it, doesn't it, Ms. Toon? Right here.
But it doesn't have any of the other information on it.
Ms. Toon, my question simply is, are you aware that your attorney submitted this with your name on it after making those representations to Judge Hoffman?
I mean, I wasn't sure. I don't know about this.
You never seen it before, have you?
I can't say that I never seen it because I don't remember, but not that I know of or remember.
Okay. I want to look at now Exhibit 125, starting with Bates number 2795, all the way through 2800. Do you see this as an email from your lawyer regarding a deed that you were going to sign? Do you see that?
Yes.
And do you see in this deed, or this email from your lawyer, he puts in all bold, if possible, kindly include the exclusions to the warranty reflected in the attached exactly as written. Did I read that correctly?
Yes.
And then your attorney attaches a deed, right? Here's the attachment.
Yes.
And let's look at what he carves out, Ms. Satoon.
Okay.
He carves out, he says, this conveyance is executed, delivered, and accepted, subject to all ad valorem taxes currently due and owing. Did I read that correctly?
Yes.
So he's carving out in this deed the $20,000 that you and your husband owed for taxes. True?
I'm not sure because I don't really understand it.
You don't dispute that this is the deed that you and your husband eventually signed, do you?
I don't know per se, but I don't think it's the last deed that we signed.
You don't disagree that you signed this deed and sent it to the title company, do you, Ms. Satoon?
Well, I'd have to see if I signed it because I don't know.
Okay, let's look at Exhibit 125, starting with Bates number 2846 through 2853. Do you see that in front of you?
I see an email here.
Ms. Satoon, before we get there, you were a licensed real estate agent when you and your husband bought this property and had it built on Maple Springs, weren't you?
You know, I'm not sure. I might have been, but I don't know exactly when I had my license or it expired or whatnot. But
You don't dispute that you were licensed as a real estate agent in the state of Texas until 2018, do you?
I don't know what year it was, but because I wasn't really working that much doing it, but I could have been.
So you know what a deed is, right?
I've heard of one. I've never really worked with it.
You've never worked with a deed?
No.
You've signed deeds, have you not?
No, I don't think so. Maybe if we bought the property, but I didn't really work as a realtor.
Well, you signed multiple deeds in this property, didn't you?
Yeah, probably buying the property, yes.
And you and your husband have flipped homes, haven't you?
Yeah, but I don't do any paperwork or things like that.
Well, you drafted a contract that formed the basis of this entire lawsuit, didn't you?
I don't really remember doing that.
You don't remember your testimony when you told the judge earlier in this case that you broke into your husband's email account, drafted a contract, and sent it to my client?
Objection beyond the scope of this trial, Your Honor.
Ms. Pettit, I get it. You can move on.
All right, do you have this, you see in front of you from the title company to your attorney, it says we are in receipt of the attached warranty deeds. Do you see that?
Yes.
And then if we go to the next page, you see a deed that you signed on, or at least that's effective February 23rd, 21.
Yes.
And 1 second, you see here that you and your husband in this deed have carved out all ad valorem taxes currently due and owing. Do you see that?
Yes.
So you all were saying in this deed that it wasn't you that was responsible for the taxes, it's whoever bought the house from you, right?
I didn't know what that meant, so I don't know. I don't know. I didn't write that.
All right, let's look at this Exhibit 125, which is Bates number 3190 through 3191. Do you see that?
Not yet.
you see an email in front of you from the title company to your attorney?
Yes.
And the title company tells your attorney, Jonathan, will you prepare the deed to 2808 Maple Springs LLC? Do you see that?
Yes.
And you now understand that's Mr. Lambert's company, right?
Oh, sorry.
That's Mr. Lambert's company, the third party.
Yeah, I think so.
And your attorney responds and says, Ed, can you ring me in the AM at your convenience? Do you see that?
Yes.
And you and your husband never signed a deed to 2808 Maple Springs, did you?
No, I think we signed it as like Versailles, Dallas, and/or signs.
And you only did that after the transaction had fallen apart, correct?
I don't know exactly the timing of it.
Ms. Satoon, you're a real estate agent. You know that you can't transfer title to quote and or assigns, right?
I actually don't really know, but I think you can, both parties, I believe, can sit at the table the same day at the same time and transfer the title, or one buys the property right at the same time.
Ms. Satoon, that's not my question. You understand that to put the phrase and or assigns in a contract would actually create a cloud on title and not transfer any property?
I actually didn't know that, but that would be confusing why the settlement agreement says and/or assigns, so I'm confused.
Let's look at Exhibit 129, page Versailles 8034 to 8035. Do you have that in front of you?
Yes.
And you see this is an email from your attorney to me saying, so this is before closing, right? We're 4 days before closing.
Yes.
And you see that your attorney is telling me at this point that my client, Versailles, is now responsible for the Zatoon's moving costs, expert costs, and legal fees. Do you see that?
Yes.
Ms. Zatoon, you know that expert fees, legal costs, and moving costs were not in the buyback agreement, were they?
I don't believe so.
And so here we are 4 days before closing, and your attorney is telling us that we need to pay for moving costs, expert costs, and legal fees, right?
He's not telling you. It looks like he's just saying it's an offer or suggestion. I don't think he was trying to force that on you. He was just trying to see like what you guys wanted to do.
Sure. And that's because you guys weren't willing to pay the taxes, right? You had the carve out in the deed saying that my client had to pay for the taxes.
No, actually, we've never talked about that. I never wrote that or even suggested that. Neither did Jordan. So I don't really know exactly why that's a thing.
Well, Ms. Satoon, let's look at the deed that you signed. It has a carve out for taxes currently due, right?
Well, I really don't. I didn't know what that meant, and I didn't write it, so
Right. Your lawyer wrote it, right?
I don't know who wrote that.
Well, let's look at the email. Your lawyer says, right here, Mr. Scott, on the general warranty deed, see the attached proposed deed language. Please note the specific exceptions to the warranty. Do you see that?
Oh, let me see. Okay, yes.
And then the exceptions to the warranty are right here. Carving out real estate taxes. Do you see that?
Yes.
All right. Let's move on to Exhibit 129. Exhibit 8034. Actually, I want to look at the release. Is this the proposed release that you and your husband signed regarding the last two parts of the buyback agreement? Is this your signature at the end?
Yes, that is.
And this is a settlement and release agreement?
Yes.
And so we saw in the prior email that your attorney is telling us 4 days before closing that he says, under the statute, your client is responsible for moving costs, expert costs, and legal fees, right?
The statute, let's see. I guess for the RCL buyback, maybe. But He really was just trying to offer a suggestion, like he said. It wasn't something he's telling you have to do. I wasn't involved in this conversation, but that's what it looks like.
Okay, let me just ask you this. Does Mr. Scott say on March 4th? What I'm saying is that under the statute, your client is responsible for the Zatoon's moving costs, expert costs, and legal fees. Isn't that what he says?
It looks like he said that. Yeah.
Okay. Then we look at the release, which is the only release that you and your husband signed. True.
I think so.
And paragraph 11 says this release does not apply to the parties pre-closing and closing obligations under the statutory buyback, nor release any other rights and remedies, claims, or causes of action if the opposing party fails to strictly comply with its statutory obligations. True?
Yes, it says that.
So the release.
What exhibit number is this?
Sure, Your Honor. This is, it's part of Exhibit 129.
And that's paragraph 11.
Yes, Your Honor. Also, it's in here twice. It's also, let me give you the bait stamp for this. It's Versailles 8636 through 8640. And also, I just want to make sure clear. Hold on. Yeah, that is the correct Bates range, Your Honor. Okay. Ms. Satoon, just 1 second.
Ms. Pettigrew, while you're looking at that, we're about to break for lunch. There was a comment made that concerned me a little bit.
Sure.
About Mr. Lambert. He is going to testify in this trial, correct?
Yes, Your Honor, we intend to call him.
Okay. I very much want him to testify, and there was a comment made that he may not testify, and I guess I can't force you to make him testify, but it would be very difficult for me to make a decision with that.
Sure. So what happened on that is Mr. Scott had continuously told us that Mr. Lambert was going to testify. Told us that as recently as yesterday. Then apparently now he does not want Mr. Lambert to come and has filed an affidavit with the court and a Rule 11 agreement saying that he's not going to call Mr. Lambert. But certainly we agree, the court's got to hear from Mr. Lambert to see if Mr. Lambert was ready, willing, and able to purchase that day. And we'll show to Your Honor that he was. So we will call him in our case in chief, assuming Mr. Scott does not call him.
Judge, we're very happy to have Mr. Lambert come in and testify. They can call him on their case. Absolutely.
Guys, let me ask you this. Do you want me to leave this link open during the lunchtime, or do you want me to just close it and you guys sign back on at 1:30?
If we can leave it open, I think that'd be easier.
Okay. I'm going to turn the YouTube off, but I'm going to leave the link open so you guys